Afternoon, members. Please take your seats. Good afternoon, members. I welcome you again at this post-lunch session. Post-lunch session will be taken by CS Dr. K.S. Ravichandran, his partner KSR and Company Secretaries, Coimbatore and Chennai. The post-lunch session will be taken on NCLT and NCLAT rules 2016. On behalf of NIRC, I welcome Dr. K.S. Ravichandran sir. I request sir, please raise the dais. Sir, please. Requesting Chairman NIRC CS Manish Gupta, please come and present a bouquet to Ravichandran sir and to facilitate him. Sir, please. I would like to take this opportunity to brief the profile of Dr. K.S. Ravichandran. He is the managing partner of KSR and Company Secretaries LLP. He is a fellow member of the ICSI. He holds bachelor degree in law and master degree in commerce. He obtained the doctorate of philosophy from the Department of Management, University Post in research on corporate and criminal laws in India and UK. He started his career in India Air Force and served as a specialist in Russian radar system for 9 years. He also served as a lecturer in commerce for the government of Arunachal Pradesh for a brief period before taking up practice as a company secretary. He was a member of experts subgroup constituted by the Ministry of Corporate Affairs for studying the suggestion related to chapters of the Companies Act 2013. He has authored several books including Secretarial Securities and Management Audit, Prosecution of Directors, Relief and Remedies, Secretarial Audit of Compliances, etc. He is on board of Karur Vyas Bank Limited as independent director. He is a member of the Secretarial Standard Board. He is also member of National Council of Corporate Frauds and Internal Audit of ASSOCHAM, New Delhi. We, on behalf of NIRC, again welcome you, sir. Requesting members give a big hand to Ravichandran sir. Requesting Ravichandran sir, please proceed with the meeting. Sir, please. Welcome.
Thank you. Good afternoon to everyone. It is interesting to see that a powerful tribunal has at last come in place with 432 declaring that any party to any proceeding or appeal before the tribunal or appellate tribunal, as the case may be, may either appear in person or authorize one or more chartered accountants, company secretaries, cost accountants and legal practitioners or any other person to present his case. So my case was that any other person is something which is required to be underlined and we should think about it. That 432 authorizes company secretaries, chartered accountants, cost accountants, legal practitioners to appear before the National Company Law Tribunal and the National Company Law Appellate Tribunal also. Both NCLT as well as NCLAT, now there is a very big change, a quantum jump in the various powers that have been conferred upon the tribunal. Huge, we can say. And further, you go to the level of appellate tribunal, from where the appeal lies only to the Supreme Court. And therefore, it assumes all the more importance. Not that appellate tribunals, company secretaries were not entitled to appear. For instance, Competition Appellate Tribunal. Even I have appeared before CAT, Competition Appellate Tribunal, argued matters of cartel. Dr. Chandrasekharanji has appeared. Securities Appellate Tribunal is a well-known forum where many of our fraternity have appeared. But there is a great difference when we talk about a tribunal, and that to an appellate tribunal, and connect it with Companies Act and connect to your heart. See how it goes. Therefore, it gives us a lot of great feeling. But as is the case of every task, this task is also very tough. It's a tough task. It is a very tough task which requires years of hard work to master the various situations that may arise in the courtroom. Various things will arise, and there are a lot of situations in which presence of mind, rather than the procedures and rules, will help you. That is how we will pick up. I have had a couple of experiences after the NCLT was established, benches were established. Very, we can say, brief period, and we have got only some about 1 month, 2 months now, that's it. And some places even the infrastructure is not ready. So that is the situation, but it's a good start because the law is new. Subject may be already there in the 1956 Act. Most of the provisions, principles and propositions of precedents can be used. The law is new. We are going to enter into greater areas of practice, remunerative practice. And the tribunal is also new. Members are also new. So this gives us a lot of confidence to put in the required amount of efforts in each branch within the powers of the tribunal and come prepared and win. That's it. So this is a brief introduction I thought we should have about this NCLT and NCLAT. Somebody used to tell there was an afternoon session in the court. Normally, when we usually appear in court, this 2:30 we cannot sleep, even if you had only curd rice. This 2:30 we have to wait there, stand there, the calling will be there, and you have to rush to the front and argue your matter. So where is the question of dozing? Kaun sala ye kehta hai? This you would have heard, is it not? So the senior on the other side was upset because of the language used, and there was of course clarified that kaun sa la ye kehta hai. Is it not? That was clarified. We can do a lot of things, and sometimes you will regret because you have a lot of fun. You may do some humorous things, but the judges may not understand. For all you know, judges may not understand the law also. The branch of law they may not know. That is real. Only with long years of practice you will know that you know better than any other person. Yesterday one person was appearing before NCLT Bangalore. His case was first and mine was second. He was saying that, see, this financial year of the subsidiary must be aligned with the financial year of the holding company. It is a 241 case, and only 9 months I just want from April to December. I think your lordship knows everything. In Tamil movie there is one Vadivel who has acted in a movie, in a courtroom scene. He tells the Lord, "My Lord, you know the provisions." Whatever is befitting the situation, accordingly you can quote the provision and give the punishment. That is a lawyer. And similarly, so yesterday I was listening to him, he was saying, everything is known to you. All annexures, holding company ka balance sheet, sab kuch isme, and I have kept it. Then the judge is asking, you should have put flaps. You have not given numbers. You have not at least put the flaps to know what is the annexure which is being enclosed. Ease of reference is not there. So then the judge was saying that, okay, I am granting. There was not much to do because he said, you know everything. See, I am sitting here. How will I say I don't know? Tell me. It is not possible, no. Being on the other side, that day in Chennai bench I was arguing a matter. I have done a couple of matters already in different benches. No, that's not required. I think will do. See, Chennai bench, the other side has sent one junior. Sometimes you will hear all these tamashas. Some youngest person will come and he or she may not know anything about what is the case. Will come and simply stand and say, I am representing so and so. Please post on a short date. That means get an adjournment, that's it. Maximum the thing they will be able to speak is only this much. Please grant adjournment. Please post short date, subject to your convenience of the lordship. These are all standard language. You can see some lawyers arguing, my lord, my lord, my lord. What is the argument? वो तो कुछ नहीं होगा. Every second word is my lord. So you understand? First word is my. So the other side was not able to tell what is the case because it is their case. And still, they are the petitioners, they were not able to tell. So I just helped the bench, saying that there is an arbitration petition. By filing this, they are delaying, and counter also they have not filed. So I just made a small, very, very 1 minute explanation. So both the judges were asking, why you are not filing the counter? So she cannot tell anything. So I helped, saying that whenever an application under Section 8 of the Arbitration and Conciliation Act 1996 is taken out, that should be done prior to filing of the written statement, that is counter. Not after that. You lose your right to pray to the court that this matter shall be directed to arbitrator or arbitral tribunal is an application which can be made under Section 8 prior to filing of the written statement, not afterwards. So I had to explain. So you get lot of opportunities to enjoy. It's a really, we can say a lot of circumstances will be there in which you will be standing in the court when a lot of people are sitting. Of course, I will not see who is sitting. Now I can see everyone, whether with chashma or without chashma. Whereas in the court, you will be addressing the court. So you do not know what are the people sitting and what they are making fun or what, I don't. Nobody will know. And therefore, you will not have any problem of addressing the court alone. Sometimes you will be addressing the court thinking that the court is awake. But it may not be the case. Sometimes they may be also slightly dozing. And finally, some order will be, at the request of the parties, the matter is adjourned to some other date. So therefore, this kind of experiences, we can say fun-filled situations, at the same time tense situations, will be arising. There are various provisions. We have found it under the Companies Act. Unlike the Company Law Board, lot of powers have been conferred upon the NCLT. So recently, our office has sent out a newsletter with the title Is BAFR Functioning? If you take BAFR alone, there is a doubt in the mind of a lot of people whether this 50% erosion there should be reporting, 100% erosion there should be reference, whether BAFR is there or it is not there. So many people are asking because 2003 the Repeal Act was passed. Then 434 came under the Companies Act 2013. 434 said once the powers are shifted and the provisions come into force, the proceedings, the appeal, the reference, the enquiry and whatever before BIFR, IFR will stand abated is what 434 says. Now the Insolvency and Bankruptcy Code has come. That has removed that 434, that clause. It has brought 8th schedule. Under the 8th schedule, 2003 Repeal Act is amended, brought the same abatement clause under the 2003 Repeal Act in class B of class 4, subsection B. So you can understand there are so many things which have to be connected, which should be understood. So how do we present matters? Whatever be the subject matter of the case. The first and foremost thing is to understand what is this tribunal is all about. Therefore, I thought in the first 15 minutes or less than that, we will give an intro. Let us have an understanding of what is the NCLT, NCLAT. You know that the Gandhi versus Union of India is very popular, like Thiru R. Gandhi we say. So, company secretaries will know definitely two Gandhis. One is our nation, father of the nation. And we have Thiru R. Gandhi, because of whose case the 2002 amendment never saw the light of the day. And in 2016, 1st June only we are seeing NCLT with the partial powers conferred upon it. This case took not less than a decade. And finally the amendment came, then 2013 Act came. That also we are going to see further changes because of the amendment by the Insolvency and Bankruptcy Code. You can see the 11th schedule of the Insolvency and Bankruptcy Code and see that. So there are certain things which are required to be noted when you are addressing a tribunal. So even though the tribunal has already come and this case has become a thing of the past, you have to think of the past and go through the decision because it talks about tribunals. It talks about what is this tribunalization. And that is the case where the Supreme Court said, all courts are tribunals, all tribunals are not courts. Tribunals one notch down the court. So Supreme Court said, all courts are tribunals, but the reverse is not true, the vice versa is not true. All tribunals are not courts. So tribunals have less powers than a court. So we can go with that kind of an understanding of what is this body before which you are appearing. For that purpose at least, this will be very useful. These are all the public domain matters, that there are benches, that there are rules. That is the 2016 rules for NCLT and NCLAT by the notification of 21st July. There are some sections, provisions under which certain powers have been granted to the tribunal. We will start with the NCLT, slightly move on to NCLAT later when it comes to the rules. These powers are already there in the Act and I think most of us know as a matter of list that there are certain powers under various sections which are granted to the tribunal and subject to tribunal clearing it only, such matters can be taken up. So I am not going through all these various powers which are conferred upon the NCLT to the extent they have been operationalized. However, when you look at the major powers of NCLT, 230 to 240, not talking about the time, sections 230 to 240, scheme of amalgamation and arrangements. It's a very interesting provision. Income Tax Department recently issued a notice to a company in respect of a matter which involved reorganization of capital. It was a case where the company had 10 rupee shares on which only 1 rupee was paid up, and 1 rupee shares on which 1 rupee was paid up. So two classes of equity shares. I am telling actual case, okay. One class is 10 rupee share, only 1 rupee paid. Another class is 1 rupee share, 1 rupee paid. The company had reserves. They went for reorganization of capital. They said, we will bring 9 rupees from the reserves, debit the reserves, credit the capital, add 9 rupees to the 10 rupee shares, make them fully paid up, and make this 1 rupee share 10 rupee. That means for every 10 shares of 1 rupee, you get 1 share of 10 rupee, and pay 9 rupees because there will be only 1 rupee paid. For 10 shares, you will get only 1 rupee means 10 rupees, whereas it should be 100 rupees, correct? So for each share of 10 rupee, they have to give another 9 rupees. So bring everything from the reserves and used the section 94 of the 1956 Act, and they went ahead in the scheme without looking at 391. Very interesting case. Whether 391, like 230, reorganization of capital, you can see the rules also. Specifically, certain provisions are given. Cases may not end with the company's boardroom, company's general meeting, and tribunal alone. It will go beyond that. It requires application of mind. We should be able to understand and differentiate between 94 and 391. Whether it stops with 94 only or it is a case bordering in 391, so you should have gone for approval of the High Court, sanction of the High Court, is a very important question. Because so far as the income tax is concerned, then it becomes income in the hands of the individuals, and if suppose somebody has highest number of shares running into crores of rupees, he is getting benefit, that can be challenged. So what we are supposed to understand is, where is the full stop? Before or without tribunal we can do something, and where is the commencement of the jurisdiction of the tribunal, so that you go to the tribunal only. This is where we have lot of things to think. I will give you one more example. Let us take the case of preference shares. Let us take the case of preference shares where the rights of preference shareholders is there, and they want to give extension of time for the due date for redemption of preference shares. Within 20 years, of course. Manlo they want 5 years redemption, it should have been made. But now they are saying, okay, we are agreeable to extending the due date up to another 10 years or 5 years, whatever it is. With the preference shareholders agreeing, Section 48 can be used as variation of rights of shareholders and have the preference shares due date for redemption extended. At the same time, you may read Section 55(3), which talks about approval by the tribunal. Now, whether it is a 48 matter only, or does it come under 55? Whether we should go to the tribunal? Similarly, every matter at the office, at home, work must be done. When you go and present any matter in the tribunal, homework is very much essential, because when you go there, like me, after coming here, you should not sit there and read the rules. That is why always we are used to arguing for hours. So without touching the rules, I can finish the day. Actually saying, it is possible. You have to do a homework to prepare thoroughly about the matter. When we talk about procedures, most important procedure is this, that studying the provisions, studying the facts, preparing a synopsis, having a dates and event chronological order, understanding the whole bunch of things and present it. For instance, yesterday when I was in Bangalore, the members asked me, Acha, what is the turnover of the company? Of course, the client was sitting in the behind. The MD, the director, everybody was sitting. All the way they have traveled 500 kilometers and they are sitting there. When I rose up, I was about to argue, nobody was there. But as I started making presentation, these people have come, I think. I didn't notice that, they have come. After finishing, I turned this side, they are sitting. Why I am saying this, let me tell you. The judge asked me, what is the turnover of the company? So I don't want to tell actually what is the turnover because my knowledge was 3 years old. It was a 2011 matter. 2013 balance sheet only I have seen, not after that. So yesterday they asked me what is the turnover. I didn't turn over and see the people. Otherwise I would have asked them. Okay. I didn't know. So I said, see, this is one of the oldest companies. You can tell something. Somewhere you can take them around. It is one of the oldest companies, my lord. Probably one of the oldest companies. In fact, it was 1913 Act. They were doing some ginning and cotton pressing business. Nowadays they are doing in a very little way only. In some property matter there is a dispute. That is why we have come before you. Like that we finished it. So turnover gone. I have also gone because when I turn this side they are there. And what they will think? I didn't come prepared. So in tribunal you will have the client sitting. Plus the other side always waiting to pull the rug under your car, this thing. Pehle wo karo. So therefore there must be caution. How do you prepare yourself? What is the most important procedure we should know is the procedure of sitting and reading the provisions, understanding the facts of the case, preparing a synopsis, seeing whether this is the right forum, do we have a choice of forum, and is this the best choice or better choice, and what are the dates and events chronologically, what happened first and what happened next. If you organize your thoughts like this, your presentation will be at least clear. You should be able to tell what you want. That is the most important. In adversarial matters, the case is still difficult. So when I talk about 230 and 240, 230 and 240, most of the matters will be procedural in nature. Actually, even today what is happening in high courts is that mostly application, general meeting ordered, general meeting, report filed, petition, notice ordered, go to ROC, RD, OL, get the reports, submit it to the court. If there are objections, that will be heard. Mostly nothing will be there. Everything will be ticking the boxes. When the judge says everything is done, done, compliance, done, finished, sanctioned. This is what is happening in the courts. But entire case will be reported with the name of the lawyer only. Company secretary would have prepared, using his brain, a beautiful scheme. With such a beautiful scheme, features, and consultancy with a lot of people of the company for bringing so much of benefits, cutting down costs, reducing taxes, all the things would have been done. A paper will be presented in a procedural manner and that will be ticked. And that's it. In 230, 240, you can take it from me, we should be very, very carefully preparing the procedures and papers and showing to the court, I have complied with all these things. And that's it. Hardly certain situations, certain objections will come. So 230, 240, of course, powers have not yet been operationalized, but it is procedure. Next one I have written there, you see, CIRP. This corporate insolvency also, corporate insolvency resolution process is also procedural in nature mostly. Except with when you want some adjudication. Oppression mismanagement. In the Chartered Secretary, I wrote this article this time. I think the July issue was a special NCLT issue. So I pointed out that when we talk about 241, the notification says, you can see this interesting thing here. See 241, the notification talks about class A only and doesn't talk about class B. See, this is what I am reading. 241, subsection 1. Any member of a company who complains that class A, affairs of the company have been conducted in a manner which is prejudicial to public interest, or in a manner prejudicial or oppressive of the members, or in a manner prejudicial to the interests of the company. There are only three things. Or the material change not being a change brought about. So you can see the 397, 398, same thing comes. Then you come to 242. 242, if on any application made under 241, in relation to, you can say, oppression mismanagement, the tribunal is of the opinion that the company's affairs have been or being conducted in a manner prejudicial, oppressive, etc., etc. Then you see the conjunction and. Class B, that to wind up the company would unfairly prejudice. Therefore, as an alternate remedy, 397, 98 or 241, 246, except 245 comes. So therefore, what is happening is the O&M jurisdiction, oppression mismanagement, is nothing but an alternate remedy. But this class A is introduced, class B is not introduced. Please see the notification. It is incumbent upon the applicant to show that the winding up of the company would unfairly prejudice. Otherwise, facts of the case would justify the winding up of the company on just and equitable ground. So the situation should be so horrible that it is just and equitable to wind up. However, as it would unfairly prejudice, you have an alternate remedy. So when our friends notified, they have not notified those clauses where the words winding up, reduction, all these things were appearing. So today we are arguing before tribunals for this oppression mismanagement matters without this class B in requirement. Technically speaking, as class A is not yet come into force, you see the conjunction and. There are two things under 242(1). It is A and B. Now B is not there. So it is a one-person company. This is how it works today. And similarly, you see subsection 2, class C. In the case of purchase of its shares, as aforesaid, the consequent reduction of capital, the word is reduction. This word comes under 230, 240 only. Those provisions have not been conferred upon the tribunal. So class C is not possible. So when you go to the court today in tribunal, ask for purchase of shares as a remedy and give order for consequent reduction, it is not in force. Now similarly you see 246. How many things we are supposed to note is what I am trying to tell you. The provisions of 337, 341 shall apply mutatis mutandis. This means the surcharge proceedings like Schedule 11 of the 1956 Act. This is not in force now. So you can't go to company law, the tribunal, National Company Law Tribunal, ask for surcharging the directors for losses caused by them, to recover money from them. What is that we are trying to tell? The important point is, in these matters, you have a lot more to do. These are very adversarial. Both sides are there, or many sides are there. Jurisdiction issues are there. Principles are there. So we should be thoroughly prepared to deal with these cases, unlike the first two were mostly procedural. Class action suits, surcharge and all will be, we can say, of one notch above, little tough, and therefore thoroughly you should know how do we understand what is the consequence of provisions, what is the effect, what are the powers. Then 422 tells that powers must be exercised and cases must be disposed of within 90 days, and at the best the president or chairperson of the NCLT or NCLAT respectively can grant extension of time by another 90 days. This is for both appeals as well as petitions. Whenever there is a bench, it should be two-member bench who can exercise the powers of the tribunal, of which one shall be a technical member, one shall be a judicial member, and the other shall be a technical member. It is possible for even a single member to exercise powers of the tribunal is what 419 says. So single member being judicial member only, this is possible. Then if suppose they want the transfer of cases to be done, it should be posted to two-member, it is possible, they should apply. The judge has the right to require that to happen. 419 continues. The president may constitute a larger bench also, because the decision is by majority. The decision of the benches, in two-member bench, there could be one person saying yes, I will grant this, another person saying no. There can be tie. Even in Sestat matters, so many other matters, I have seen such kind of things when the matter will go to a third member and thereafter the decision will be on the basis of majority. So this is about the powers of the bench, and there is a power to constitute even a special bench. Majority decision will stand, is what I said. Civil procedure. Look at the powers of the court. The tribunal and appellate tribunal will follow principles of natural justice. That is why there are several decisions of the Supreme Court which says rules are handmaids of justice. No tribunal or court will look at a procedural matter and reject a substantive right, because they are, after all, rules are made only to ensure that there is a proper process and systems, but that shall not be ruling at all. What is important, these are all procedural rules, so that we follow a particular system. Most importantly, they should be guided by the principles of natural justice. Certain powers are given from the Civil Procedure Code. Apart from that, what we have is the principles of natural justice. The tribunal and appellate tribunal, they have their power to regulate their own procedure, and that is how these rules have come. This is not like the Companies Act rules. This is different. These are all for regulating the procedure to be followed in the tribunal. You can see there are various powers which I have put here. Powers of civil court, summoning and enforcing, receiving evidence is one important thing which I have said. Normally these are all matters dealt with by affidavits and counter affidavits. When we come to the rules, we will probably able to deal on witness examination, examining a witness on oath, and evidence, expert evidence in some cases. These are all the usual procedures which are necessary for the purpose of exercising the powers properly. One such power is, you can see here, dismissing a representation for default or deciding it ex parte, setting aside any order of dismissal, any representation for default, or any order passed ex parte. These are all the powers by virtue of 424 tribunals and appellate tribunals have. From there only the rules flow. The output, the decree of the court, it is equivalent to a decree of the court for the purpose of enforcement of orders. remember this also. All proceedings are judicial proceedings. You see how important declarations are made in these provisions like 419 and 424 and all. What is the impact of judicial proceeding is that there may be a case where somebody can misguide, somebody can file some frauds, the fabricated documents may be into problems. Perjury can be, application can be made under 345. It is possible for invoking the provisions of the CRPC and ask the tribunal to file a complaint for offence of perjury under 195 read with 340 of the CRPC. So the proceedings are judicial proceedings. You have to be very careful. Do not ever give in to any attempt for making certain representations which are not true. Making some papers which are generated, fabricated or manipulated. Do not ever succumb to that level and get into difficulties which it is very difficult to get retrieved. The purpose of 424 declaring the proceedings before the tribunal and appellate tribunal as judicial proceedings is a very, very big provision. It is not to be ordinarily thought that judicial proceeding, okay, it's illegal in court, that's it. This is not the way we understand it. You read with 195, 340. In fact, once in Bombay bench when CLB was there, I had a very interesting, of course the member was also very keeping everybody comfortable. His name was A.K. Tripathi ji. So I was telling I am presenting a petition under 195, 340. He said like this. He is A.K. Tripathi. So this kind of opportunities will be there. You will have to understand how important these language is. Judicial proceedings is not to be ordinarily understood. It has got, we can say, far-reaching ramifications. No jurisdiction to civil court is a beautiful provision under 430. We have filed an application in one of the cases in a civil court for rejection of plaint on the ground that under the Companies Act 2013, civil court's jurisdiction is barred, like section 18 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993. Same way, jurisdiction of civil court is barred on any matter on which power has been conferred under the law, under the act, or any other law, for example LLP or something like that. On the NCLT, NCLAT, jurisdiction of civil court is barred. No injunction shall be granted by any authority in respect of any action or any matter. This is the beauty of 430. So when we took out the application on the basis of 430 and produced a lot of authorities and principles, immediately the plaintiff came and said, I am removing the name of the company from the array of parties. So defendant 1 removed. He said, I don't have any jagda with the company, I am removing the company. So you can understand how this can work. Understanding 430 can help you in some other place also. So the substantive provision of law has got lot of inputs that gives you. You will be able to apply thought on various provisions like this and then move on. Then only you will get the confidence built up to appear before. As CS, it is not very difficult for us to understand the procedures. Mostly, there are some provisions in the procedures which we need to have some understanding, which will come by experience. However, generally it is not very difficult for procedures to be understood. But these principles, the issues behind it must be understood. All proceedings are judicial proceedings. I have already said no jurisdiction in civil court and 430 I have told. Who can appear? I have already shown my 32. Then Limitation Act applies is something which we need to remember. Okay? Thereafter, of course, these are all appeal matters and transition issues which will be for the time being issues. And with this, the introductory part of the NCLT, NCLAT, the provisions of law, the background with which we are going to deal with the procedures can be, we can say, closed. We will go to the rules now. I just wanted to take your time to only certain rules and not everything. We have already About 30 minutes more is available. See, if you look at the rules, pleadings, you please read this. This is a very important definition. Normally, what happens is, when we talk about application, petition, counter, written statement, statement of defense, rejoinder, surrejoinder, these words are generally used in the courts. In different proceedings, civil proceedings it is different, CLB proceedings it is different, in some other proceedings, arbitrations it is different, criminal it is different. So, we should have primarily an idea that these are all constitute the pleadings, where you prepare applications, you give affidavits, statements, counters, rejoinders, all these constitute the pleadings. In the pleadings only, mostly questions of facts will be addressed, all the facts will be set out, all the cause of action will be set out, all the reliefs that you want will be set out. So you should be very careful to understand these pleadings. This is part of the definition now, so it gives a lot of understanding. Then, I just wanted you to read this procedure, how the applications, proceedings must be initiated, which is there in 20, rule number 20. Cause title means what? On the top of the application, it should be written before the National Company Law Tribunal. This is a very important thing, and specify the bench, principal bench, Bangalore bench, Chennai bench. This is a very simple procedure, but sometimes it is not properly done. It should be done. In fact, I was wondering whether the margin, you see this rule 20, it is, I believe you are able to see, I think I can expand it little more. An inner margin of about 4 centimeter. So you have to go with a scale. What to do? See, the measurement you have to have, no? 4 centimeter width on the top, and with a right margin of 2.5 centimeter. Left margin, there only we will know whether it is right or left, we don't know. See, you are in tension, no? So much of this thing is there, you will be wondering whether this is left or that is. You will be left with no time for this. So you carry a scale, 2.5 centimeter, left margin 5 centimeter, duly paginated, indexed, stitched. Tailor ko bhi in paper book form. So I was thinking that only in India this kind of numbers, margins and all required to be given. Courts also have. So recently I had an opportunity of looking at, not dealing with, a Californian divorce case. So they gave the papers of the petitioner as well as respondent. Then it is written on the top itself, this paper is not to be submitted to the court. Big bold letters they have written. The attorneys have prepared so nicely, they are setting rules of procedure internally in their office that you should collect all these papers from the party, and on the top it is written, this paper shall not be submitted to the court. This is only for homework. So sometimes you give that also. Then Nietzsche I read, the application shall be on 8.5 inch length paper, breadth so much. So then only I realized rule 20 is nothing. All these margins, A4, legal, so many size of paper, and double line space, 1.5 space, 1.15 space. So many things are there in this usual thing, and sometimes judges will throw if it is not properly there. So therefore, at least first time, when you do, apply thought on the procedural aspects. For example, affidavits. When you draw the affidavit, many times this question will arise, in the High Court, should we put notary or not? Or it can be before the advocate, or it should be on stamp paper, or it should be on green sheet. Hundreds of small questions will come. And unless you have worked in a firm with all this experience, there will be nothing to see. So we have to be very thankful to the rule makers, because they have clearly said you should have a scale, measure this 4 centimeter, 2.5 centimeter, etc. and ensure that this procedure is followed. Because yesterday the petitioner was asked to give 2 copies of the petition. I told them already 3 copies are there with the bench because I have done the inspection. But still the judge said under the new law you have to give 2 copies. Then what to do? He has to make another 2 copies, and he said, then Lordship may kindly grant me 15 days. 2 copies of the petition ke liye, how nicely he is enjoying the time. You see. So he got 2 weeks time for giving 2 copies. So understand that the information that you are furnishing in the petition, in the affidavit, in the manner in which it should be done is very important. Please take it. I am not telling this rule because it is difficult for you to read. No, I am just highlighting the importance of this. I am sure every one of us can easily understand, sometimes wonder what is this. Matter is important, not the form. Sometimes you may think, but this is how works. Full legal size. 25, note down rule 25, lodging of caveat. It is not easy to lodge a caveat unless you know who is likely to take out a petition or matter against whom. Who is supposed to be or who is expected to be filing a case is important. Against whom or against various people, all those people you should have idea. If you have lodged a caveat without hearing your side, order will not be passed. So therefore, Rule 25, unlike the Company Law Board Regulations 1991, where this was not there, but as a matter of practice, caveats were accepted, understand there is a provision for lodging caveat. And therefore, it is possible for you to use the Rule 25 and do it. Sub-Rule 2 you read, it is valid for 90 days. Rule 20 I have asked you to read. Understand now, Rule 25 we have gone. Rule 27, normally even at the time of final arguments, we have to scratch our head like this. See, I forgot to bring the translation. Because everybody will not be able to read the documents in different languages. So we have to provide a properly authenticated translation document of all this. Sometimes the advertisements would have been in some local language, sometimes some affidavits must be there, sometimes some court orders can be in some local language. The judges may not understand, but as a matter of whether the judge knows this language or not, Rule 27 applies. Therefore, any document other than English language intended to be used in any proceeding, you should have a translation. It should be certified to be true translation by the authorized representative or by any other advocate or authorized representative. Please remember Rule 27. Then I take you to Rule 32. Rule 32 is interlocutory applications. Sometimes you might want an urgent inspection, an urgent commissioner appointment, an urgent injunction for preservation and protection of rights, properties, shareholding patterns, composition of board of directors. Therefore, Rule 32, interim applications can be made for stay, for direction, for condonation, for exemption, for anything it is possible. Then I take you to, of course this advertisement and all is not required. We will go through the 38 service of notice and processes. This is how that it is different from the Company Law Board Regulations. Here the tribunal is supposed to be giving the notices and processes. Please read that, and it is very interesting to note the difference when you make a case or petition. You should have idea about it. Then you have the evidence. In evidence, what we mean is, evidence is nothing but a document or record which is supporting the facts you have pleaded. I told you about pleadings. So if you want to say that this is what has happened, for example, incorporation, you can provide the certificate of incorporation. Removal of director, you can provide the resolution, DAR 12 and whatnot. So like that you can give evidence. And Rule 39 and Rule 40 on evidence are fundamental rules, very important. But Rule 40 alone I am reading. Please have one point in mind. Rule 40, notwithstanding anything contained in 39, the parties to the proceedings shall not be entitled to produce before the bench additional evidence, either oral evidence or documentary evidence, which was in his possession or knowledge, but was not produced when the inspection took place or investigation took place. At the time of inspection and investigation, in case a document or information was in your possession and you did not tender the same, furnish the same to the inspector or investigating authority, you lose your right to produce additional evidence. Is what is a substantive provision in the Rule 40. So this is very important, because the inspection officer, inspector or investigating officer would have prepared his case according to the documents you have produced. Therefore, you should be very clear and understanding that Rule 40 removes your right. Then hearing, 44. 44 is also interesting and important. The tribunal shall notify the parties the date and place of hearing of the petition or the application, as the president or any member may be, by general or special order direct, where at any stage prior to the hearing of the petition or application, the applicant desires to withdraw the petition or application. Just like that you can't say, and I want to withdraw. Read Rule 44(2). The tribunal, on hearing the applicant, if necessary, such other party arrayed as opposite parties in the petition or the application or otherwise, may permit such withdrawal. 44(2). A withdrawing of an application is not an ordinary thing. Just go there and for the mere asking you will withdraw. No. Cases of class action suits, cases of oppression mismanagement, there are opposite parties and they will be getting a right to allow you to withdraw or not. This cannot be just like that withdrawn. Rights of party to appear before tribunal, this we have already read in 432. Whatever you have to make, you get a wakalatnama or a memorandum of appearance as per the applicable form and give it. And in respect of central government, in respect of regional director, registrar of companies, official liquidator may authorize an officer, advocate, company secretary, etc. to represent in the proceedings before the tribunal. That form is explaining that. Yeah, for 45(3) doesn't mention, but connected form mentions that these officers may be able to engage the services of company secretary, chartered accountants also. That is one important point. 46 is important. 46 see, we have always been having this problem of those who are practicing before the tribunals and company law board and all. When you have trainees, you will not be able to make them represent. But now 46 clearly says, no intern employed by an authorized representative shall act as such before the tribunal or be permitted to have access to the records and obtain copies of orders of the bench in which the authorized representative ordinarily appears. Please understand the next sentence. Unless his name is entered in the register of interns maintained by the bench, like court clerks. So if you are not going to appear on that day because you have other tribunal matter or some other matter, and your intern is going, in turn you have to ensure that his or her name is entered in the intern's register. Then only when the turn comes, he can go and appear. So therefore, there is a rule now under 46 which provides for this. What is the next important rule? Rule 48. Rule 48 says, ex parte. In case, you see where it works. You are the applicant. Matter is posted for hearing. You are not appearing. Tribunal may, in its discretion, either dismiss the application for default. For example, 241 matter, financial year. Applicant is not present. It can be thrown. For example, oppression mismanagement matter. Applicant is not there. They may hear and decide on merit. It may not be dismissed for default of the applicant alone. 48.2 says, where the petition or the application has been dismissed for default and the applicant files an application within 30 days from the date of dismissal, satisfies the tribunal that there was sufficient cause. That is why he could not come. It is possible for make an order restoring the same, provided where the case has been disposed of on merits. Even though the applicant was not present, it was not dismissed but heard and passed on merits, there is no question of reopening. Let us understand 48 clearly. Then comes 49. On the date fixed for hearing, respondent does not appear, but applicant appears. The respondents are not there. Tribunal may adjourn the hearing or decide the matter ex parte. First one we saw, applicant is not there, dismiss the application or take it on merits, pass orders on the basis of papers. Second one, what we are seeing, respondent is not present, set him ex parte, proceed. Where a petition or application has been heard ex parte against a respondent, such respondent may apply to the tribunal for an order to set aside. That is important, to set aside the order declaring him ex parte. If such respondent satisfies that there was sufficient cause and that is why he could not come, and in that case the tribunal may pass an order setting aside the ex parte hearing as against him on such terms, that means cast, provided where an ex parte hearing of the petition is of such nature that it cannot be set aside against one respondent only, it may be set aside against all or any other respondents. So we have to remember these type of important rules, because these are all not normal rules like make 3 copies, add fees and all. It is not that rule. These rules are rules of procedure only, but lot of importance is there. So we should have an idea when this will come, when such a requirement comes. For example, 2-3 days back when I was appearing in one matter, I was referring to rule 110. I will take you to 110 now, right now. 110, default of appearance of the respondent and consequences. Where the respondent, despite effective service of summons, does not appear before the date fixed for hearing, the tribunal may proceed to hear the appeal application, etc., and pass final orders on merit. Please understand, I have gone from 48 to 110. See how much I have travelled. Here you are talking about final orders. Here you are talking about a case posted for final arguments, and thereafter what happens if the respondent doesn't appear. So the respondent may be set ex parte, and it is possible for the counsel, the tribunal to take some assistance if necessary of the some amicus curiae or something. So let us understand this can be used. So immediately I showed to the tribunal that under 110, please declare ex parte, or at least issue an order that next time also he doesn't come, ex parte will be declared. 110 will be invoked. I also pointed out to the judge Please read 113. Whenever tribunal deems fit, it may award costs for meeting legal expenses of the respondent of defaulting party. The tribunal may in suitable cases direct appellant respondent to bear the cost of litigation. That is different. Defaulting party, there can be a... So I was telling that why don't you give me some 5,000 rupees at least as cost. So there are cases where these rules can help you if somebody tries to drag the matter, prolong the matter. Whenever such things come, understand, an understanding of the rules will help you at the relevant time to tell. That will be useful and therefore you can have. And whenever you don't have records fully, you apply this 114.15 to understand, make an application to have an inspection. What are the papers available? What papers? Sometimes no, their papers may not be available. It might have got lost, or it would have come from some other company secretary or lawyer or somebody. So you have the right to do the inspection and ask for papers, copies, everything. And there is a prescribed rules for inspection. The entire part I will read out. This is about 114, 15, 16, 17. All these provisions which come under this 14 chapter, that is part 14, is very important. Many times we have used this inspection. Authorized representative, how he should appear and all, it is there. There is not a problem for us. We know how it should be done. And professional dress, 124. While appearing before the tribunal, you can't sing. There is some lungi and all, you can't go. One song is there. Authorized representative shall wear the same professional dress as prescribed in their code of conduct. So maybe regulations we can take it and go in a proper attire. That is what they are saying. Then we have only 2 or 3 things. 131 to 134. Discovery, production and return of documents. I was handling one 397/98 matter in company law board. At the time, the vice chairman was Mr. K.K. Balu. He used to ask me, Ravichandran, why do you want to fight with only 100 shares with you? I am the petitioner. So every time the hearing starts, he will tell this. Arey, aapke paas 100 shares hai. Why don't you take the money and go? Like that. It's like that, no. Then I used to tell immediately, Lordship, 100 share is not the question. Look at the substantial rights which have been prejudiced. Look at the fraud played by the respondents. That is where more important. I am not asking for 100 shares to be valued and I get some small peanuts and go out. Because that case was that the 100 shareholder with 100 shares was entitled to a first right of refusal for 6,33,000 and odd shares, which he had transferred without me, without my knowledge and without my consent. That was the case. So when 100 shares you go as a petitioner, court is bound to ask you, what is this 100 shares you are fighting? Take the money and go. It is not so easy. Articles, entrenched rights. So there may be some situations where you will require. And when I read the papers like annual return, balance sheet, we were finding that mind-boggling things have been presented there. Nobody knows what is the real capital, what is the number of shares, when it was issued, how the capital became this much, when it was transferred to somebody, and that too outside the country. All these things were problem. And so many people were there as respondents. So I took out one simple thing. Suddenly it occurred to me, I will send 3 questions to them, interrogatories. So I sent it to all the people. 3 questions I asked. What is the capital of the company? How many shares are there? When did you pay the money for that? So it's very simple questions apparently. Common sense will tell you that this is not a big complicated question of law. But these questions clinched the deal for me. Because they have produced a share sale agreement And they were not able to know what are the number of shares in the company when the shares were sold and the company was taken over completely, throwing me out. The question which was addressed by me was that Company Law Board has jurisdiction even though transfer has taken place in England. Because situs of the shares is Indian company, Indian shares. Like that, you will have opportunities to use the ordinary thing like what is the capital, how many shares are there, when did you bring money, such small things. Show me the return of allotment, show me the register of members, which is the primary evidence. Such small things can clinch you the case. But you should apply mind at that time. And of course, I lost in the Company Law Board. That matter, on the question of law, I was able to succeed, but on the facts, without hearing, some wrong order was passed. Then we had to go to the High Court for appeal, and in the High Court we won. It is a reported decision. You can see in Ramaya and so many this thing. WW Apparels. It's a very interesting case in which UK receivership was challenged by me. Very ordinary questions, but very beautiful provisions and principles have been brought. Therefore, discovery and production of documents is not an ordinary stage. 131, you want to make an application for discovery or production of documents. Suppose you feel that the respondent has some papers in his custody and you want to ask papers. He has filed a counter with so many statements. You don't have proof of those documents. You can ask for discovery. You can ask for a direction to produce those documents and thereafter do your job. Provisions of chapter part 17, 131 and all, it's very interesting and important. When it comes, you have to apply thought and do it. Marking of documents is a usual procedure in every court, arbitral tribunals. Here they have given you whatever petitioner gives, whatever appellant gives, mark it as A series. So they will mark A1, A2, A3 like that. Then whatever the respondent gives, it shall be B series. Suppose there are so many respondents and different respondents bring different documents, that rule they have not written. Maybe we will put B1, B2 like that. Something like that we have to do. Then tribunal's exhibits will be marked as C series because some inspection reference case must be there. And some cases the marking will not be done because it is not reliable document. So they will put X series. This much is there at least in the rules, but there is more to that in practice. Then I want you to go through part 18. Two people were on the one side, one person was on the other side, in a director, in a board with 3 directors. A notice was issued that tomorrow the board meeting will be held. You know, under secretarial standard, unless a majority consents, such a charter notice is not possible. But still it was issued. For what purpose is that? To see whether it happens or not. Suppose it happens, okay, we were able to. So therefore, the 2 people who are together, he said, I am not well, you people come to my residence, board meeting can be held even in Antarctica, so you can come, coolly we can have it here. So it happened. Next day was 15th August. He files a criminal complaint saying that he came along with some more people. We call it as henchmen. In criminal complaint we used to put henchmen. And they threatened both of us. They have made us sign the minutes, attendance, passed the resolutions, appointing 2 more people. And that is how the Independence Day was celebrated by us. So we just told the police officer, in dono ko separately you ask. So first the senior was called. So he was asked to explain what happened. Cross-examination, like that. It's not a courtroom, but even in the preliminary, you will be able to understand the truth or not. So oral evidence, is a very important evidence whenever a documentary proof is not there. Documentary proof is the sufficient evidence. You do not confront. That's it. There is no issue. But there are cases where oral evidence may be useful. Witness demeanor, that is how he behaves when you ask him questions. Somebody tells you lies, across his face you look at, you will understand whether it is correct or not. The moment I leave the floor, a lot of people will tell, great lecture. Then I will understand clearly. So this gentleman said, it started at 4 o'clock, but he has signed in the attendance, 4:22 it started. He put so meticulously his signature and he has put 4:22 p.m. So when you inquire, as a police officer inquiring what happened, he tells one story of different time and different circumstances and all. The other guy comes and tells differently. That itself shows it is a false case. So there itself it was closed. But in courts, there may be such requirements where you may not be solving a puzzle by affidavits and counter affidavits only, which will require somebody to go to the witness box and give evidence, oral evidence, or somebody to be cross-examined when he gives evidence. That will probably help you. Therefore, understand examination of witnesses and issue of commissions. These provisions can be used if necessary. How do we do whether it is necessary or not? What is the core fundamental fact involved? The proving of that or disproving of that will clinch the case. Apply thought. Second, look at the documents. Sufficiently available? Forget it. If it is not sufficient, then only go for all these things. It is not at all necessary, because there are cases where the minutes book will become the evidence. On that basis, examination will take place. So these provisions are very important, which are there as part of this. Generally, as I told you in 230, 240 matters, or any other provisions where procedure is involved, sanction and approval and clearance is given by tribunal, this part will not apply. Only in class action, only in oppression mismanagement surcharge proceedings, these provisions will be useful. Other things, I am not going into that now. It is not very difficult. I just want to take 153 and close this NCLT rules by that. Where any period is fixed under these rules or granted by the tribunal, there is a possibility for getting the extension of time, enlargement of time, even though the period fixed for the rules is over. So just read 153. Sometimes when time is over, 2 weeks are granted, and within 2 weeks you are unable to do. There is some sickness, there is some foreign trip, so many bahanas are available. You can write a book on excuses and apply with one such excuse and get enlargement of time. Otherwise it is going to be difficulty. So 153 gives you a power to, gives the tribunal to enlarge the period within which something must be done, whether by rules or by the tribunal order. 154. Whenever you read the order and find lot of mistakes, clerical errors, arithmetical mistakes in any order or any error arising from there, accidentally slipped or omission, you will be able to apply to the tribunal, get it corrected. Sometimes an order may require an appeal to be preferred, but it contains mistakes. Apply under 154, get all these corrections done, and thereafter go to the appeal. Or some other authority may be relying on that. There is an order, you want a bank to act upon it. You want a registrar to act upon it. You want a joint venture partner to look at it. There are mistakes. That mistakes may be required to be corrected. So those things must be done. 154 is a provision, interesting provision, for rectification of order containing clerical arithmetical mistakes or inadvertent accident, slip or omission. Okay. Then we have 161. This is like the 391/94. You will have to file certain orders with the registrar of companies. That comes under 161. Then I think I will move to NCLAT rules for a few minutes, and that will be the end of the session. NCLAT. Power to exempt. Rule 14, appellate tribunal may on sufficient cause being shown exempt parties from compliance with any requirement of these rules and may give such directions in matters of practice and procedure as it may consider just and expedient. So you should ask some valid things. If there is a difficulty, you can ask for it. Exemption. Rule 17. All adjournments shall normally be sought before the concerned bench in the court, and in extraordinary circumstances, registrar may allow. Please understand, you have to go to the court and ask for adjournment. Then the next one is translation. I have already said this is not required, this is all same only, and yeah, 48 issue of notice, 49 summons, and 50 steps for issue of fresh notice. Suppose you give notice and it doesn't reach the destination, it is possible for asking for a fresh notice to be issued. So from 46 you can come to, if it is coming back unserved, you can ask for fresh notice. The applicant, petitioner or authorized representative shall within 7 days from the date of notification takes steps to serve the fresh notice, is what is written under 50, and consequences are there in 51. When the issues are there, you will have difficulty. 53 explains what type of difficulty is on the cards. When respondent, despite effective service of summons or notice on him, does not appear before the date fixed for the hearing, the appellate tribunal may proceed to hear the appeal ex parte and pass final orders. Ex parte orders in final appeal, you see, from there it goes only to Supreme Court on questions of law. Provided that it is open to the appellate tribunal to seek the assistance of authorized representative as it deems fit, if it involves intricate, complicated, substantial questions of law, questions of wide ramifications, is what Rule 53 says. These are very interesting things which are required to be noted. There is a possibility you miss the deadline, it may be the end for that case. Then we have only one more thing to read. This marking of documents and all these things we have already finished, examination, etc. we have already said. The pronouncement of orders, then one more thing is there, SLP, we will come to 100. 100 is important. A register in form NCLAT 9 shall be maintained in regard to special leave petitions or appeals against the orders of the appellate tribunal to the Supreme Court, and as the entries therein be promptly made by the judicial bench. The register shall be placed for scrutiny by the chairperson in the first week of every month. These are all procedures with respect to Supreme Court orders. In the NCLAT itself, these things will be maintained. And the last thing is about the removal of difficulties, notwithstanding anything contained in this rule. Wherever rules are silent, no provision is made. Chairperson may issue appropriate directions. So this will be used whenever during the course of procedure it will come. I just want to wind up this opportunity for this presentation with one interesting thing I will tell you. 104 I referred only for that. There are a batch of 3 cases filed before the company law board, which has come up before the tribunal now in Chennai bench, of which two are coming before the two-member bench and one is coming before the single-member bench. All the three have identical questions and they have to be decided as a batch. So the single member says, if it has to be posted before the double member, then you apply to the president, get the case transferred so that all three can be dealt with. Because the power to transfer the case or post it from a single member to double member is all with the president. All the people have to run to Delhi and then they make this application. Thereafter it will be posted, then it will be heard. So therefore, whenever such matters come, removal of difficulties order may be issued under 104 so that automatically it gets posted, dispensing with the requirement of running up to the president, taking a lot of time and running out of time for 422 purposes. 422 gives you only 90 days. So what I have done in the interregnum is, told my client, let us not run to the president and all. We will tell the single bench that there is a double bench hearing, because after all this man is also comprised in the double bench. So he is going to hear the two applications which are before the double member bench. So on the basis of orders, this can be disposed of. Just post the matter after the date of hearing fixed before the double member bench. We overcome with slight trick, applying thought and dispensing with this precedent requirements so that you achieve the purpose. And because the same member is going to sit as a double member bench also with another person. So 104, I have found already one reason why a removal of difficulties order under these rules also can be issued. And that brings an end to this NCLT, NCLAT rules discussion. I believe with the given short time, we have been able to discuss some of the important points which I was able to understand and share it with you. I thank NARC for all this opportunity, and I have also learnt, as I told you, and here only I just read the rules. Thank you very much. Yes, sir. Yes.
Right? Is there any provision for the cost or imposing the post compensation?
Award of cost on the defaulting party is separately given. It can be, you can ask for it. I read it out, no? So many times it has been done, sir. So many times. You can, thousands of illustrations can be given, and that too in Companies Act with so many, every day some board meetings, some filing and all taking place. You have to apply for amendment if there are substantial issues. Amendment of petition, amendment of pleadings is possible. Rules do not prescribe. Yeah, the members will decide. Some cost will be levied if it is. Initially, I don't think they will put it. But there are cases where, for example, recently a Supreme Court had levied 25 lakhs cost in one of the matters. There are so many, but this 25 lakhs was probably one which recently it was done. Yes, sir. Yeah, this NCLT to NCLAT. So ordinarily you have the power, and interesting thing is, it is on facts as well as law. You can rehear, the NCLAT can rehear the entire matter. Unlike 10F appeal in the High Court arising from orders of Company Law Board, where questions of law alone was supposed to be the subject matter of appeals. On question of facts, it ended with Company Law Board. So what we used to do is we take the decision of Justice Rumapal in Dale and Carrington, where it was said an order which is perverse in nature can bring a question of law. So we have to use some principles and all. But as a matter of statute, from Company Law Board order, under section 10F of the 1956 Act, only on questions of law appeal was allowed. And thereafter, of course, SLP. But here, we have an NCLAT which can hear the entire matter again. And from NCLAT, there is a right which is a statutory right of appeal. Please understand, the matter that goes to Supreme Court is a right given by the statute to a party who is aggrieved, constrained only by questions of law, that's it. But the right of appeal is not with any leave. It is based on the statute. That is the difference between what we had in the 1956 Act and what we have now. NCLAT, then Supreme Court. Nobody be between. High courts are there, but in this, this is not. Yeah. I just took a lighter side of it, that's it. Yes, sir. Two 240. When do you want it? I want it today. ठीक है sir. Pray Lord Rama.
So do I need to file an application in NCLT 1? Matlab, is it mandatory? Because I'm asking this because I'm not getting the difference between NCLT 1 and 9. When I read NCLT 1, there on the heading it is given that it is for the Rule 34 and so many rules
A lot
are
of
defined
rules are mentioned there.
there. Right, but in
Yes.
NCLT 9 it is written Rule 72, 82, 83 and general form. If the-
General, correct.
Right.
Ah.
So do I need to file my petition in NCLT 9 or 1?
Which is the subject of your case?
It is related to the appointment of an internal auditor. It is in the act. It is not defined that you have to go to the tribunal. But I myself want to go for the compounding. I want to go for the compounding. So do I need to
Nine.
go in 9? So, but when I'm reading that NCLT 9, the format I'm reading, it is specifically it is given that in the case you are filing an appeal or against the order you are going against the order of the tribunal, then you have to go into NCLT 9 because the format is given.
See, today you can see the fees. Unlike other company law board matter, Rule 88. I will read out Rule 88. Reference to the tribunal may come from Registrar of Companies. One such section which is referred to is 441
Right.
of the Companies Act, Rule 88.
I know.
And it talks about form number NCLT 9.
9.
And if you see the fees, even for NCLT 9, fees is prescribed, 5,000 rupees.
Exactly.
Why I say this very immediately is, I will share with you this. Yesterday, the Bangalore bench asked me whether it should be the form, what should be the fees. So I pointed out, I am saying this. Therefore, there is no difference between you, me or the tribunal. Everybody is reading the rules and understanding things. Exactly, it happened yesterday. So I was helping them. Nowadays, no reference is coming from registrar on a compounding application. But still, there is a form and there is a fee
Right.
which is to be paid. And he was asking, now compounding fee, whether it should be first collected before issuing order. All the old questions again coming back. So I told them, you issue an order, ask him to pay within 1 week, and if he pays, it is getting realized, then issue the compounding order.
Okay, one more thing I want to know.
Yes, sir.
If I go in NCLT 9, then I'm facing an issue that in my case, the officer in default are, for example, there are 2 officers in default and companies also in default. So do I need to file a separate application on behalf of everyone? Because in the format is specifically defined that I solemnly affirm. So can I file a combined application or do I need to file different three
I
applications?
suggest you file separate applications.
3 applications.
Because each one is an offender. Number
And-
1.
oh.
For each you have to pay 1,000 rupees.
For every, okay.
For each section, each subsection, this will be done. This is how, unlike the form NCLT 1, if you read NCLT 1, first title you see, all the rules they would have put. Instead
Right.
they should have put in accordance with NCLT rules.
Right.
All the numbers are there.
Exactly.
That way we can't make applications.
Okay. Thank you.
So it is 4:45, we have exceeded the time. The bench is, for the next day we have to, it is a Saturday also, no? Correct, no? Thank you.
Member, please be seated for only 2 minutes only. Members, please. Thank you, Ravichandran sir, for deliberating on the topic NCLT and NCLT rules. I believe member must have got benefited through his presentation. Requesting Ravichandran sir, please share the PPT so that we may share with members of the ICSI. Requesting CS Central Council member CS Ranjit Pandey sir, please come and present a memento to Ravichandran sir as a token of respect from all of us. Members, please give a big hand to Ravichandran sir, please. We will share this recording at YouTube and share the link to the members also. With this, we formally conclude this seminar. Thank you to all the participants who have attended this seminar. Thank you everyone. Thank you guys.